What is the downside to divorce mediation? Mediation can seem like a calm alternative to a litigated divorce, but it has drawbacks that could put you at a disadvantage. In New York, judges may refer appropriate cases to mediation, yet success depends entirely on both spouses participating voluntarily and negotiating in good faith. Mediators maintain neutrality and cannot provide legal advice under Part 146 of the Rules of the Chief Administrator of the Courts, so you still need a lawyer to review any settlement before signing. This limitation means the mediator's role is to help you reach any agreement you accept, not to protect you from giving up important rights. Because mediation lacks formal discovery tools such as subpoenas or depositions, you might not uncover hidden assets or financial details that could surface in litigation. Although court-ordered mediation programs require sworn statements of net worth, voluntary mediation relies on both parties to disclose information honestly, and incomplete disclosures undermine fairness. Power imbalances between spouses can undermine mediation, especially when one partner has greater financial knowledge or uses emotional manipulation. A controlling spouse may pressure the other into accepting unfair terms just to end the conflict, and mediators have limited tools to address this dynamic. If there is a history of violence or intimidation, the victim cannot negotiate on equal footing, and a judge's involvement may be necessary to ensure safety. When a spouse refuses to provide financial documents, misrepresents income, hides assets, or uses mediation to delay, you will need the enforcement power of the court to compel disclosure and move the case forward. Even if mediation resolves some issues, unresolved conflicts must still be decided by a judge, so you could pay for mediation only to end up in court. Because mediators cannot give legal advice, an attorney should review your settlement to ensure it complies with Domestic Relations Law Section 236 for spousal support or Section 240 for child support. A legal representative can explain your rights and help you avoid agreeing to terms that do not protect your financial future. Hiring your own legal advocate ensures that someone advocates for your interests and can identify unfair or unenforceable terms, preventing you from waiving important rights. If you decide to proceed with mediation, take proactive steps to protect yourself by requesting tax returns, bank statements, retirement account records, and business financial documents. Establishing guidelines for respectful communication can reduce intimidation and help both parties speak freely, but mediation still requires cooperation from your spouse. A law firm experienced in Manhattan divorce matters can guide you through these steps and ensure fairness. Divorce mediation generally includes an initial consultation, information gathering, negotiation sessions, drafting the settlement agreement, and filing the agreement with the court. After you resolve all issues, the mediator drafts a written settlement agreement that each spouse's legal advocate should review carefully before signing. If mediation fails on even one significant issue, you must file a contested divorce action, which can be expensive and emotionally draining. Knowing the downsides of mediation empowers you to make informed decisions about your divorce and to protect your rights in New York. Divorce is a major life transition, and while mediation offers a less adversarial alternative, it is not a one-size-fits-all solution. By consulting a skilled attorney and understanding the legal limits of mediation, you can choose the path that best secures your family's future. Juan Luciano, divorce lawyer. Manhattan is ready to help you evaluate your options and safeguard your interests. Call our law firm at 212-537-5859 or visit us at 347 Fifth Avenue, STE 1003, New York, New York, 10016, United States for guidance tailored to your situation.